welcome. I'm Mark Mix, president of the National Right to Work Legal Defense Foundation. Today, we want to go over some things that have been happening over the last couple of weeks here in Washington, D.C., particularly things that have been happening in the litigation sector of our operation here, the National Right to Work Foundation. Obviously, we have been around since 1968. We have, at any given time, about 250 active cases on behalf of workers all across the country at all different venues in the court system. And today I've got as a guest one of our long-term, most experienced lawyers, Glenn Taubman, who's with me. He's been with the foundation for 38 years. We got him when he was really young, and we've held on to him because he's such a great litigator and such a great representative of the type of individuals that we help through here at the National Right to Work Legal Defense Foundation. Glenn is primarily doing work with the National Labor Relations Board and private sector labor management relations questions that come up. He's been an expert on enforcing some of our Supreme Court decisions, like our Beck decision that we won at the U.S. Supreme Court back in 1988, and other cases where he has been primarily responsible for establishing precedents that protect workers all across the country. So Glenn, welcome. It's good to have you here today.
Thank you.
Glenn, if you could summarize the last 4 weeks of what's happened to your litigation practice since Joe Biden has taken over the White House and used the executive power to change the way your litigation is looked at, what would you be saying to our supporters and the folks that are watching about what's happened over the last 4 weeks?
I would say that there's been an earthquake under our feet for working men and women in America. The last 4 years that we had under the prior administration were years where we were really able to advance the ball, where we were able to create many new precedents for workers' rights. We had board members and general counsels that were receptive to our arguments and allowed us to really move the ball forward. Now, in just 4 weeks, the turnaround is quite unbelievable. Guidance memos being revoked, cases being pulled, actions to overturn our precedents, and this is only in 4 weeks. It's quite extraordinary.
Yeah. Glenn, how long did it take the Biden administration to start upsetting the framework which you had been working under the last 4 years?
Well, it took them, I think, the first 20 minutes after President Biden was inaugurated, because he fired General Counsel Peter Robb in the first 20 minutes after he took office. And Peter Robb was a staunch supporter of the right to work principle and all of our cases. And Peter Robb was really somebody who turned the bureaucracy of the NLRB that had been oftentimes against us. He made them work for the working people of America, and he was fired within 20 minutes by the president.
Yeah, Glenn, that's a really important point you make, because for the longest time, even under the Bush administration, the two Bushes, and even under the Reagan administration, there was this sense that the National Labor Relations Act, which is this federal blanket that was thrown over the private sector back in the Franklin Roosevelt years, basically taking labor management relations from the states and bringing it back to Washington, D.C., which is always a mistake. But right. The point is, it seems like for the first time under the Trump administration that the National Labor Relations Board and his appointees actually considered the plight of independent workers. Primarily, it had been this notion there's these battles between big business and big labor, and they clashed, and it was this tennis match. Anytime the administration changed, they said you were favoring employers or you're favoring big labor union bosses. But right now, over the last 4 years, and your litigation proves this, that there was actually concern about the individual worker, that the General Counsel was receptive to the fact that workers had rights under the National Labor Relations Act, as opposed to this titanic battle between big business and big labor. Can you talk about that a little bit?
Sure, that's 100% correct. I've been doing this for 38 years here at the foundation, and labor law is always has been viewed as this titanic struggle between management and unions. And we represent the workers. We give voices to the workers. We protect their rights. We help them decertify if they're dissatisfied with their union. We push the envelope for workers. And that has been an uphill struggle throughout. But in the last 4 years under this administration, We had General Counsel Rob, we had board members that understood that there's really a third party, an equal third party in all of this, and that's the individual workers themselves, and they have a right to be heard and they have a right to have their rights protected. And that has come to a complete dead stop under the new Biden administration.
Yeah, and what that means for employees in a couple of cases you've got is that some of the progress that we'd made over the last couple of years with the General Counsel and some of their advice memos and things they were directing this vast regional directors network that's out there across the country that is adjudicating labor policy is probably going to get run over, and we'd have to kind of restart. But you know, Glenn, that's one of the things that we've done here at the foundation. We continue to take these cases to fill up this pipeline, knowing that when the right case comes along, or even sometimes a very obscure case, that we can actually expand into a greater protection for workers. For example, the Mount Air case that you're representing workers in Delaware, up there, about 800 poultry workers at a plant in Delaware. You took a case where the union officials and the employer negotiated a contract that had an illegal clause in it. And the employees wanted to get out of the union, but yet they were blocked by these old antiquated precedents created by the board, not by statute. But you used this one case to potentially expand protection to a larger workforce based on the litigation that you're handling. Can you talk about that a little bit?
Sure. So the National Labor Relations Board has encrusted on this statute a whole series of bars and blocks. I mean, imagine that. You want to have your election for your congressman, for your senator, and you go to vote, and they go, oh, wait a minute, you can't vote. There's something going on that prevents you from voting. Well, the National Labor Relations Board, over decades, encrusted these policies of blocks and bars, a contract bar, a successor bar, a settlement bar, you name it. They've come up with any rationale that they can to prevent employees from decertifying and to lock incumbent unions in place. And in the case that Mark references, Mount Air Farms, there was a contract in place, an illegal contract. The NLRB found that the contract had an illegal forced dues clause in it. And so we said, well, the contract's illegal. Why apply this contract bar to prevent these poultry workers from getting out of an unpopular UFCW union? And the Trump NLRB granted our petition for review and is right now looking at that case and looking to get rid of the contract bar. And that's just one example of what we do here, and what I do in a lot of my litigation is to try to get rid of these bars and blocking policies that prevent incumbent unions from being ousted, even if 100% of the employees could want them out. But most of these NLRB rulings will say, oh, tough luck. You'll have to wait a year. You'll have to wait 3 years. You'll have to wait till notices are posted. It's always wait if you want to get the union out, but it's never wait if you want to bring the union in.
Yeah, in fact, Glenn, there's legislation working its way through Congress, introduced a couple weeks ago, that would make it dramatically easier for union officials to impose their representation on workers across the country. And it starts with repealing all 27 right-to-work laws that are currently in place across the country. These are laws, 5 of which have been passed in the last 9 years with the work of our sister organization, the National Right-to-Work Committee. And one of the things that the Biden administration and Speaker Pelosi and Majority Leader Schumer want to do is wipe out any protections that workers have to hold union officials accountable. Glenn, you've been involved with our work for 38 years, and just to kind of bring this to a close, can you talk a little bit about why would an attorney stick around for 38 years? I mean, I'm interested. Our litigation staff, we have 21 staff lawyers, and there's a very large segment that have been here for, well, there's a couple guys that are more senior than Glenn. We have one, our legal director, Ray Lajeunesse, will be celebrating his 50th anniversary with the organization here very shortly. What is it about the foundation that keeps you here and keeps you motivated and keeps you coming to work in the morning?
Well, that's a fantastic question. And part of my answer is to say thank you to Mark for running an organization like this. We are a family here. We allow lawyers to grow and to bloom in their practice here. if you begin a case here at the National Right to Work, even an obscure little case, if that case works its way through the court system and ends up at the Supreme Court, you will argue that case at the Supreme Court. So this is a place that fosters talent, and not only that, but we're all on the same mission. We're a very collegial organization among the attorneys. We always are talking about the cases and how do we advance the ball for individual employee rights. And so this combination of knowing that you start a case, you will finish that case, and knowing that you have a team behind you, and knowing that we're on the right side. You know, I've said to Mark many times, sometimes I feel like I'm looking at this huge stone mountain, and I'm just here with a little hammer banging away at the hammer. But every once in a while, you'll cause a huge fissure in this rock. And that's what we do here. We take these laws that are really encrusted to make it difficult for employees to protect their rights, and we keep banging away until we win.
Yeah. Well, Glenn, it is a real privilege to work with you and your other colleagues up and down Legal Row here at the Foundation. But most importantly, we owe thanks to those people that give to us some of their disposable income because they believe in liberty, because they believe in freedom, because they believe in an America where, in this grand experiment of self-government, that individuals have rights. And unfortunately, our labor policy has kind of created these cartels and applied this monopoly power. And if it weren't for the support of our donors across the country and those that have been with us for many years and those that are new to us and learning about our work and supporting it, we couldn't do this work. But it's been a privilege for me to be involved with the Foundation and with lawyers like Glenn, with a little operation here that's been to the U.S. Supreme Court 18 times, that has established precedents in the law that have impacted and freed literally thousands, tens of thousands, hundreds of thousands of workers from the yoke of compulsory unionism, and it's not possible without your support. So, Glenn, thank you for being with me today and spending a little time. You've got plenty of work to do, so we're going to let you get back to your office because things are changing probably since we've been sitting here.
Thank you.
But to those of you out there who are watching, thank you for the opportunity to bring this little quick presentation about our legal work to you and about what's going on here at the Right to Work Foundation. It's a privilege to work with you and for you, and we'll continue to fight for individual freedom and worker freedom in the country. Thanks.